Good afternoon, I'm Olivia Sharfman, here to argue the negative of the resolve that businesses should have the right to freely exercise their religious beliefs. First off, I would like to touch on the definitions clash that has already started in the debate, and I would like to bring up the fact that the entire point of the affirmative argument is to argue something different from the status quo. Under their definitions, they're basically defining it so that businesses have freedom of religious expression so far as it doesn't infringe on others' rights. However, they already have that right to religious expression. This debate is about a clash of rights, which they bring up in their second contention about which rights are more important. And I think that it's unreasonable to define the resolved in a way that it agrees with the status quo. Therefore, I think it's reasonable to proceed with a definition that's a little bit more productive for this debate. Now I would like to touch upon their first contention. Their first contention surrounds legal precedent. The phrasing of this debate is about whether or not businesses should have this right, not whether or not there's already legal precedence for it. So I think that this entire first contention, which lists a bunch of Supreme Court cases, isn't necessarily applicable to whether or not businesses should have the right to freely express their religious beliefs. Second of all, sorry, this is coming down. Their second contention is that there's a hierarchy of civil rights. And their main point is that religion is listed first in the First Amendment, therefore it is the most important fundamental right, and we should hold that above speech, life, liberty, and the pursuit of happiness, which I think is absolutely unreasonable. In the hierarchy of civil rights, people's right to life is more important than their right to deny people services on the basis of religious expression. If someone arrives at a hospital with an ectopic pregnancy out of wedlock, the hospital does not have the right to deny them services solely because they think that their actions are immoral. A hospital should be obligated to save that person's life, whether or not it disagrees with their freedom of religious expression. We are talking about people's right to life, and I think that that absolutely takes precedence over freedom of religious expression in this debate. And seeing as this debate is solely centered around rights clash, I think that that point solely wins for the negative side. I also wanted to bring up under that contention that they conceded that all rights have restrictions. They said that the affirmative was arguing that all rights should have restrictions, which is strange because the resolved is that businesses should have the right to freely exercise their religious beliefs. So going under what they conceded, the idea that all rights have restrictions, the idea that you can't scream fire in a crowded movie theater because it causes people clear and present danger. I also asked the question in cross-ex, does denying people health care, does hospitals turning people away put people in clear and present danger? And the answer is absolutely yes. And this is why we need to put restrictions on religious expression when it comes to issues of life. Their third contention was about compelling interests. And I asked why the government exists. The government exists to protect people's individual rights. If the government all of a sudden allows people's right to expressing religion to infringe upon other people's rights, which it will if you're advocating to change the status quo, the government is no longer protecting those individuals' rights. In fact, you are giving the government the right to define their compelling interests. The government's rights do not take precedence over individual rights. The government exists to protect those individual rights. Therefore, their third contention is null. Now I would like to go through and support my two remaining contentions. Our first contention is that the free exercise of religion by businesses will inevitably infringe on individual rights. We brought up a couple examples of this surrounding life, but now I would like to talk about other things like employment and providing services. I asked if sexual orientation was a choice. They said, of course not. Neither is race and neither is gender. Businesses are not allowed to discriminate against people because they're African American, for instance. So why should they deny someone employment because they disagree with their sexual orientation and they think it's immoral? That's absolutely morally wrong and should not be condoned under the law. Therefore, not only are you infringing on people's right to life, people's right to privacy, but you're also infringing on their rights against being discriminated against. You can say that the affirmative would be true in all cases except cases of discrimination, but that's just arguing for the status quo, which is exactly against the spirit of arguing affirmative in the first place. Our second contention is that the resolution does promote unjust discrimination. Historically, religious freedom has always been used as an excuse for discrimination. We saw what happened in the 60s, and we, as a people, voted for a government that made laws to prevent that discrimination from occurring. These laws must be upheld, and for that reason, I urge you to negate the resolved and stand ready for cross-examination.
Thank you. During your speech, you mentioned that freedom to exercise religion could threaten one's life. Could you please provide an example of how it could threaten one's life?
Say you are a doctor in a hospital and you vehemently oppose the idea of sex before marriage. Say someone comes in with an ectopic terminal pregnancy.
Okay, thank you. I see where you're going with this. Are you aware that under Planned Parenthood v. Casey, they ruled that if somebody had a life-threatening pregnancy, any hospital, regardless of religious affiliation, would have to perform that abortion?
And yet, hospitals have still denied people these services.
But since this is a hypothetical situation, since this is should, as you have continuously repeated, we should go with the law, what is stated. So since hospitals should provide that abortion, isn't there not a problem?
I think you're misconstruing the idea that the resolve being should is about changing
under the law. Does it not provide a solution to that answer already?
Well, obviously not.
So is the issue,
it's not working.
Is the issue in the enforcement of the law or in the law itself?
Historically, that does not provide solvency.
But the issue is in how the law is enforced, not how what the actual law says.
Someone being fined for not providing someone medical services does not make up for the fact that you're denying someone fundamental rights.
Okay, thank you. So in the last cross-examination, I wasn't able to finish my line of questioning with Sam, so I'll just pick up right here. So we talked about the Heart of Atlanta motel case, and your partner said that they were able to still be successful even though they were still racist. Is that correct?
I'm not extremely informed about that specific case.
Okay. So are you unaware of what the actual result was in that Supreme Court ruling as far as whether or not they could?
I'm unaware. That was Sam's historical example.
Okay.
But what I will say is that there were many businesses in the 60s that were successful despite the fact that they
We'll continue that line of questioning later when Sam's on the stand or when my partner speaks. That being said, do you agree that corporations can be treated as people?
It depends on the context.
Under the First Amendment, can they be treated as people?
When you're talking about freedom of speech, yes. But corporations are made up of a large amount of people. Not everyone under the corporation's umbrella might agree with the corporate.
Why does it only apply when it's freedom of speech? Where is your reasoning that says corporations should have the right to freedom of speech?
There were multiple cases that decided that.
So if you're relying on a Supreme Court case to support that belief, why can we not rely on the Supreme Court case of Hobby Lobby to support the belief that they should have the right to freedom of speech?
Clearly be wrong.
So in other words, the Supreme Court's only right when it fits the rights that you want corporations to have.
I think that there are some cases where the Supreme Court has made decisions on rights, and it's clear that those cases...
Thank you. Furthermore, just because the resolve states should, does that mean we should ignore the current situation?
Just because the resolve what?
Just because the resolve has the word should in it, does that mean we should ignore the current situation and the current laws that dictate our world today?
I'm saying if we're talking about whether or not we should change the laws, we can ignore the current laws.
But only the ones that you don't like.
No.